Hughes, McKissick, Kimwright, Brawley, and Tucker. In compliance with State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any member of the Commission has a known conflict with respect to the matters coming before us this morning. All right, the record will reflect that no conflicts have been identified, so we will proceed with Public Staff Item 1.
Morning, Chairman, Commissioners. My name is Darrell Brown with the Public Staff Accounting Division. This morning, I'm presenting Agenda Item 1, dockets E2 sub 1331 and E7 sub 1298, which address an affiliate agreement application filed by Duke Energy Progress, Duke Energy Carolinas, and their affiliate PeakNet. The companies request approval of the proposed affiliate services agreement pursuant to North Carolina General Statute 62-153B. The proposed affiliate agreement service agreement will allow PeakNet to support, install, and maintain telecommunications equipment, including but not limited to antennas, radios, and lines on the company's respective high voltage assets. The public staff has completed this investigation and reviewed the application and recommends approval, subject to the conditions set forth in the proposed order before the Commission. Further, the Commission staff has informed the public staff of some non-substantive changes of the proposed order, and the public staff has reviewed and recommends adoption of the proposed order as modified.
Move approval of staff recommendation with the minor non-substantive modifications to the order.
I'll second that motion.
All right, it's been moved and seconded that the item be approved as recommended by the public staff. Any questions or discussion? Commissioner Brawley.
Thank you, Chair Mitchell. I was wondering, these services they're providing, is that merely for use for Duke, or is that also sold to other companies?
It's also sold to other companies. The services provided by PeakNet are sold to other.
Okay, is
companies.
PeakNet paying Duke a pole attachment fee?
Pole attachments are not a part of this proceeding.
Well, I mean, or a tower attachment, or they, I mean, I'm assuming the cost of the transmission
Energy
towers
Pro.
is part of the rate base for the regulated utility. And if there is a use of that for a commercial operation, shouldn't some of that cost be deferred?
So to answer your question, PeakNet is providing the service to Duke Energy Carolinas and Duke Energy Progress.
Hmm.
Now, your question is, could you repeat that again?
Well, let me lay out what I think I understand is happening.
Sure.
PeakNet is providing communication services attached to Duke towers, transmission towers. It sounds like they might even be put up optical cable. I don't know. They are providing some services to Duke. They're also providing services to other companies who are paying PeakNet. And since part of the PeakNet's infrastructure, if you will, is the tower to which they're attached, I was wondering if part of the cost of that tower, which I believe is included in the rate base for the regulated utility, is being deferred by the non-utility services provided by PeakNet.
It's a long question.
Yeah.
If I understand your question correctly, and I would also defer to the company or Michelle, who's here as well. But if I understand your question, and to be responsive to that question, PeakNet is doing installation of telecommunications equipment on behalf for Duke Energy. PeakNet also provides this same service to other third-party companies outside of Duke Energy.
The question I'm asking is the equipment that PeakNet will install on the Duke towers provide services to companies other than Duke?
Yes.
Good morning, Michelle Boswell, Director of Accounting for the Public Staff. It is owned by PeakNet, so not by Duke. So therefore it will not be on Duke's rate base and recovered from ratepayers. And any revenues received from outside sources that would flow through possibly to Duke would be listed as revenues in their next rate case.
You're comfortable with this arrangement?
Yes, sir.
Yes.
Okay, thank you.
All right, any additional questions or discussion?
Well, I think he brings up a good point. I'd like to hear from Duke about this.
All right, is there anyone here on behalf of the utility that can speak to the commissioner's question?
Morning, Chair Mitchell and Commissioner. Good morning, Chair Mitchell and Commissioners. My name is Brady Allen. I represent Duke Energy, and with me today is Pete Henderson. He is the manager for wireless communications for Duke Energy and can answer your particular questions. Thank you.
Good morning. Yeah, just to clarify, so this agreement that's before the commission is just for services for regulated utility owned by the regulated utility. So this is just installing microwave antennas, land mobile radio equipment on Duke transmission towers. So separately, PeakNet has an agreement through Duke, an affiliate agreement that does pay attachment fees back to the regulated utility sector. And that's a file. So there's two different businesses. So in this case, we're just trying to do what we do for that other side of the business on behalf of Duke. Because they don't have the expertise. Our group has the expertise to attach the transmission towers.
Okay, well, that's the clearest answer we've heard.
Yeah.
And that's what I think that's what
Yeah.
we were looking for. It was just confusing
Yeah.
beforehand. So thank you for that.
And any of the concerns that I had have been addressed. So this was a good answer. Thank you.
All right, any additional questions? Hearing none, all in favor indicate with an eye. Is there anyone opposed? All right, the motion carries. Thanks to both of you. All right, we'll move on to public staff. Item 2, Ms. Darden. I'm not sure if you would like to present multiple items.
Yes.
Okay.
Lindsay Darden, engineer, public staff, water, sewer, transportation, telephone division. If it's okay with the commission, I'll be presenting items 2 through 7 together
All right,
today.
please do.
In docket number W-1160 subs 59, 60, 61, 64, 65, and 66, KDH WWTP filed notifications of intention to begin operations in an area contiguous to a present service area to provide wastewater utility service to a new commercial service areas in Dare County, North Carolina. The public staff recommends that the commission issue the proposed orders recognizing the contiguous extensions and approving rates.
Move approval of staff items 2 through 7.
And I'll second all those motions.
All right, it's been moved and seconded that the item be approved as recommended by the public staff. I've got a question from Commissioner McKissick.
Perhaps you can help me with this. In looking at the various applications, they involve contracts that go back to 2021, 2022, even though they're all coming for us at this time. I remember seeing one for like a car wash, as I recall, another one for a vacation rental property. But two of the others, as I recall, involved a commercial connection for a residential dwelling with 25 habitable rooms. What fits into that category that in terms of a use? I can think of one thing, but maybe you can tell me what it is actually envisioned that would be involved with those applications.
It's a unique service area because it's a commercial area right on the coast. So there's a mix of, like you had said, like car wash, there's a Kmart, there's a Food Lion, and then there's kind of like those mini mansion type rental homes that are right on the beach. And that's where there's a few of they're residential dwellings, but they're more of a commercial rental property customer, sort of treated like a small hotel. That's how the gallons per day are allocated from the 2T rules. So it's based on the number of like rental bedrooms in each of those residential dwellings that are still serving as a commercial customer.
I envision it might involve that. So, but they are required to have a commercial connection, I take it.
Right.
Okay, very good. And I saw in some of the correspondence relating to these various applications, there was concern expressed about the amount of the bonds that are being requested as it relates to the applications. And it looks as if, each one of them is getting 10,000 assigned from unassigned amount that's held. But could you address that concern that they have raised? Because they're saying that the cost and amount of the bonds based upon the size of various projects is out of alignment. It's disproportionate, as I recall.
Yes, there was a lot of back and forth, especially with the new rule, the requirement for the new franchise of the minimum bond being 25,000. And that was kind of raised in this case because typically for when you're looking at a new franchise like that, it's going to be like another phase of a subdivision. It's many, many homes. And so for this specific area where they're treating just commercial customers, where it's one application, but it's also just one customer, and their gallons per day requirement is so much less than what we typically see with our new franchise and contiguous extension applications. That's why we recommended the 10,000, because we looked at the gallons per day specifically for each application and the amount. And for these, it ranges between 26,000 and the highest one's 46,000. If you translate that to 3-bedroom residential homes, that's like between 7 and 9 homes. So the quantity is not there, and also because these are commercial customers, the risks aren't there. If there's an issue with the service, it's not affecting people's homes and affecting people's direct utilities. So that's why we assigned the 10,000 for each of these specific ones.
Got it. Looks like we have some further explanation.
Yeah, my name is Dwight Allen. I represent the Norfolk Hill Wastewater Treatment Plant. Initially, in this case, the public staff's recommendation was $25,000 bonds for each of these locations. When we went back and looked at some of the other recommendations, there were entire subdivisions of 100 homes that had the same kind of bond. What we agreed with the public staff, we worked this out and we decided we're not going to air this issue right now. We're going to talk further about it in the future, because there are some that need to be higher bonds, some that need to be lower bonds. You got situations where the company is investing money sometimes the customers invest in money. So I just want to say the public staff has been quite reasonable in working out what we believe to be a fair and equitable bond. The situation with bonds these days is the bond world has changed, and sometimes you have to actually post cash with the bank. You don't go like a bail bondsman and pay 10%, and then they agree to pay for anything if it goes wrong. You have to put up that money, and to some extent it has a deterrent effect on utilities' willingness to provide service to customers. If they've got to post a bond, that's more than the revenues they're going to get the next 10 years. You're probably not going to be inclined to do it, and it's not necessarily, in our view, in the best interest of the customer. But having said all that, public staff, we've talked about it, reached agreement on this, and we're happy with it, and we agreed that we would talk about others as they come up. So we're satisfied with what the public staff is recommending in this case.
Excellent. Any further explanation?
Yes, good morning, Commissioners. James Bernier Jr., Staff Attorney with the Public Staff. In reviewing this, the Legal Division noted that the $25,000 statutory minimum by statute applied to CPCN applications. The rules for the Commission were not updated to have that minimum applied for continuous extensions. So when reading the statute and the rule together, it says it sets a minimum $25,000 per CPCN application per system. So if a water system, 25,000, wastewater system, 25,000. So you could have a bond minimum of 50,000 in one CPCN application. But for continuous extensions, the rule still sets a minimum of 10,000 per continuous extension. And we discussed that with our engineers as well. We think that should be addressed in the future going forward. But in this particular instance, since these CEs indeed only had one connection per continuous extension, we thought the minimum 10,000, and discussing it with counsel for the applicant was appropriate in these instances. In the future, public staff still reserves the right to find that the $25,000 per CE may still apply, but we recognize that's not a minimum currently under the statute and rules for CEs.
And we actually, due respect, pointed out to them that $25,000 did not apply to contiguous extensions. It only applied to CPCNs. And the statute also says that the commission should look for contiguous extensions and set a bond which is appropriate for the circumstances of that particular connection. But yet the commission rule on contiguous extension says the minimum shall be $10,000. And that begs the question, is that really the commission looking at it and setting a bond based on particular circumstances of that particular situation if the rule requires there to be a certain minimum?
Mr. Allen, is it your position that a bond should be less than $10,000 for certain?
In some instances.
And you, okay,
But
well.
right now, we've got the commission rule, and that's what we are.
And can you, I'm sure you've been paying attention to what's been going on in the commission over the past year or so, but how often is the bond amount sufficient to cover what has to be done to a system when when the utility ceases to perform its responsibilities as it's required to do under which is the purpose of the bond, right? I mean, that to me, I mean, we're talking about the interest of the ratepayer. I mean, I anticipate and welcome a petition for rulemaking. Let's just put it that way.
And I think it probably should be a generic type thing, and I don't know, I go back a long way, and at one point, the utility always invested in these. And either they had the money or they didn't.
Well.
Now, in KDH's situation, the customer puts all the capital monthly, so their system is going to be built, it's going to be done like it's supposed to be done, so what is the purpose of the bond?
Well, who's operating that system?
I'm sorry?
Who's operating the system and who's obligated to maintain it? Question for another day.
You get $500,000
wrap it up.
bonds that are posted. And again, I'm not here to argue this today, but it was brought up and.
Well, we look forward to hearing the arguments of the parties at the appropriate time, but for the purposes
I'm
of,
satisfied with this today.
understood. All right,
Well,
Commissioner McKissick.
Yeah, I appreciate the context. I could read where there had been this disagreement. And that's why I was kind of interested in seeing how it arrived at the 10,000. And I think you provided your statutory interpretation as well as what's going on in terms of the need sometimes now to post the cash as opposed to acquiring a bond without the full cash amount. So it puts it in an appropriate context. But when I see that going on, it begged the question as to
The public
why.
staff is acting very
Sure.
responsibly. I'm not criticizing them at all. We've worked through this in a very collegial way, and we appreciate that.
And I appreciate the win-win result that you guys have come up with. Thank you.
Thank you.
All right, any additional questions or discussion? All in favor indicate with an aye. Is there anyone opposed? Okay, that motion carries. We will move to public staff, item number 8.
Morning, Evan Hauser, engineer with the Public Staff Water Sewer Transportation Telephone Division. Item 8, filed by Carolina Water Service, Inc. of North Carolina, and docket number W354 sub 427 is a notification of intention to begin operations in an area contiguous to present service area to provide water and wastewater utility service in Winston Point phases 3C, D, E, F, and G in Johnston County, North Carolina. The public staff has reviewed the notification and recommends that the commission issue the proposed order recognizing the contiguous extension.
Move approval of staff recommendation.
And I'll second that.
It's been moved and seconded that the item be approved as recommended by the public staff. Questions or discussion on the motion? Go ahead, Commissioner Tucker.
Quickly, in the docket that we received, it says that the commission is to issue an order recognizing the continuous extension and then approving of the rates. How much of the rates going up? Are they maintained the same? I couldn't glean from this. Maybe didn't read it right. Go ahead.
So this contiguous extension is for newly constructed service area. So it would be at Carolina Water Services current rates, which are applicable. They're purchase rates from Johnston County for water and sewer service.
So the rates are not going up.
No, these customers would be moving into newly developed service area.
So Hook up, everything's consistent with what previously was done, so there's no rate increase to the consumer. You consume.
It's consistent with the rates that are currently applicable to the Carolina Water Services current Winston Point customers.
Thanks, sir.
All right, any additional questions or discussion? All right, hearing none, all in favor indicate with an eye. Is there anyone opposed? Okay, the motion carries. Thank you, Mr. Hauser. We will move to public staff item 9.
Good morning, Commissioners. My name is Sashi Bhatta, engineer with the Public Staff Water, Sewer, Telephone, and Transportation Division. Item number 9 is docket number W354 sub 443. Carolina Water Service filed applications for a certificate of public convenience and necessity to provide water utility service on October 30, 2024, and to provide wastewater utility service on November 15, 2024 to Courtyard at Lake Davidson, and for approval of rates. On December 4, 2024, Carolina Water Service filed a verified motion requesting that Carolina Water Service be granted temporary operating authority to provide water and wastewater utility services to Courtyard at Lake Davidson Development and an approval of interim rates. The public staff has reviewed the applications and verified motion and recommends that the Commission issue Carolina Water Service temporary operating authority and approve the interim rates, which are the uniform rates approved in Carolina Water Service in docket number W354 sub 400, which is their last rate case.
Move approval of staff recommendation.
I'll second it.
All right, it's been moved and seconded that the item be approved as recommended by the public staff. Questions or discussion on the motion? All right, hearing none, all in favor indicate with an eye.
Aye.
Is there anyone opposed? All right, that motion carries. Thank you, Ms. Bada. We will move to item 10.
Item 10 is regarding docket number W1305 sub 38. On September 3, 2024, Flores Hempstead filed an application with the Commission seeking authority to increase its rates for providing sewer utility service in its service areas in Pender County, North Carolina. The public staff recommends that the Commission issue the proposed order, scheduling hearings, establishing discovery guidelines, and requiring customer notice. The public staff has discussed potential dates with the company, and those dates have been provided to the Commission staff.
Move approval of staff recommendation.
I'll second.
All right, it's been moved and seconded that the item be approved as recommended by the public staff. Any questions or discussion on the motion? All right, hearing none, all in favor indicate with an eye.
Aye.
Is there anyone opposed? All right, that motion carries. Thank you. It's my understanding that public staff item 11 has been removed from the agenda. Is that correct?
Charles Junis, Public.
Okay. Thank you, Ms. Yost. Go ahead, Ms. Yost. Mhm.
Charles Junis, Director of the Public Staff Water, Sewer, Transportation, and Telephone Division. And yes, I would just confirm that that item has been removed. And so what was formerly item 12, I will be presenting. Docket number W1080 sub 4 on November 15th, 2024, the public staff filed a petition for the appointment of an emergency operator for the wastewater utility system in the Baytree Lakes subdivision in Bladen County, North Carolina, and requested approval of increased rates on a provisional basis subject to true-up and approval of the settlement agreement and stipulation filed on November 15th, 2024. In addition, the public staff requested that the furnished bond of $100,000 be declared forfeited. Public staff recommends that the commission issue the proposed order.
Move approval of staff recommendation.
Second.
All right. It's been moved and seconded that the item be approved as recommended by the public staff. And I will turn to commissioners to see if they have any questions after I ask mine. For the record, I support the motion. Mr. Junis, and it would probably be helpful at this point if we have representatives of all parties come to the stand just to answer questions.
Yes, Mr. Higgins and Mr. Finley are here representing their clients.
The clients are not here, just the lawyers?
I believe just the attorneys are
Okay,
here.
that's fine. Gentlemen, if you would, come on up. And just going forward, probably good practice for those utilities and other other entities that present items at the staff conference. Be on notice, you should have someone in attendance that can speak to what you're asking the commission to do. And we may get in the habit of just routinely calling everyone to the stand to present the items to the commission so that they can answer all of the commission's questions. All right, Mr. Junis, I'm gonna,
Before you get into your question, did you want anyone from Carolina Water? So
no,
We have
I'll
Red
call
River
you
Lake
up
Creek.
if I need you, but
Okay.
I'm clear at this point on
just wanted
Carolina
to make sure.
Water's position here. The first question I have for you all in reviewing this docket, Mr. Junis, I want you to answer this. In this particular docket, which is sub 4, I didn't see any information related to customers. What's the status of the customer? I mean, I understand there's a moratorium in effect, but the customers who are receiving service, what is their, have we heard customer complaints? Have you all contacted the customers?
So we met with the POA for the community. So we talked to customers directly and their council. They are absolutely concerned with the state of the system. There are a number of undeveloped lots still in the community. And so similar to the Outer Banks Kinnikit situation, there are folks that own lots, are prepared to build and cannot due to the moratorium. There's also concerns about the quality of service. Now, typically with the sewer system, things got to go really bad before a customer notices just how bad conditions are. So there hasn't been a lot of that, but there have been some leaks in the collection system that have caused concern for customers.
Okay. Okay, you've answered my question. I just am trying to understand what Carolina Water is getting itself into here in terms of interactions with customers. Is it walking into a buzzsaw or is it not?
These customers, at least based on representations from the POA group, look forward to having Carolina Water
I'm sure they do.
replace it
All
and
right.
improvements being made.
Okay. Mr. Junis, the way I read what's been filed in this docket, in 2011, the utility, which is Lake Creek, transferred the water utility to Bladen County. Do I understand that correctly?
That's correct.
And that was done without any notification or action by the commission. Is that correct?
That's correct.
Do we know why that happened? If the answer is no, that's all you need to say.
I don't know the exact motivation. You could read into it.
Let's not read into it.
Okay.
Do you have any facts? Just tell me what you know.
I don't know the
Okay.
exact motivation of why that transfer occurred.
And do you know why the wastewater system wasn't transferred as well?
That would be because they would have to essentially operate the existing system.
And the county didn't want to operate the system.
Correct.
Got it. Do you know that for fact, or are you?
Yes, I know that for a fact
Okay.
that they were not interested in taking that on.
Okay. In reviewing the record here, Lake Creek, which again is the certificated utility, has been administratively dissolved by the state of North Carolina. As of last night, when I looked on the Secretary of State's website to determine if that is in fact still the case, it is. And so it's just unusual, at least in my view and my experience, that we've got an entity participating in something like this that has been administratively dissolved. What do you know about that? And I see your lawyer stepping up to provide some information if necessary. But did you all discuss that with the parties, and where do we stand there?
Absolutely, that was discussed, and I think Mr. Finley, who represents Lake Creek, can provide some context there.
Okay, and before we let Mr. Finley respond, and I absolutely will, this is a certificated utility that has been administratively dissolved. When did this come to the attention of the public staff?
In our investigation, as part of the appointment of an emergency operator, this is something that we checked up on and were aware of, probably for, I would say, months now.
Okay.
I don't have the exact date.
Okay. Okay, Mr. Finley, what's the status of Lake Creek Corporation at this point?
The company is doing the best it can to get reinstated by the Secretary of State's office. But what is the holdup right now is the Department of Revenue is requiring that past filings, tax filings be made and be brought up to speed. There was a potential getting that sort of bypassed with a quick way to do it. But the accountant of the company is finding out that can't be. We're going to the Department of Revenue to see if that can be done quickly. The answer is no. So it's in the process.
Okay.
That the company had been losing money, so there's no taxes that are due, but they've got to bring the filings up to date before they can get reinstated.
Okay, well, you anticipated my question and you answered it, so thank you for that. All right.
Sorry, Chair Mitchell, just to interject briefly, Davian Newell with the public staff. The public staff and the company and their attorneys had numerous discussions regarding this issue. And we found that pursuant to the statutes, a corporation can continue to carry on any business to liquidate its business and affairs as a part of its dissolution. And we thought that given that provision, it was sufficient to cover Lake Creek's being a signatory to the agreement.
Okay. All right. Thank you for that additional information. I appreciate that. Okay. So obviously the bond's going to be forfeited. The bond is $100,000, as I understand the record. The $400,000, Mr. Junis, fill me in on the $400,000.
Yes, so that is going to be a contribution from Redbird Land Company for basically to help fund the solutions that are necessary to get the system into compliance.
Okay.
This is a new path that we have forged here. We think it's important that they, as a party to this proceeding, have a contribution because they are also being relieved of some duty here, where Carolina Water is stepping in to make these improvements. So we feel like this is a significant win for ratepayers, and it's good for all parties involved, and that's why you have that partial settlement. Nobody's walking away happy, but I think we have found a right middle.
Okay. How much work has to be done to the system?
That estimate varies. It's going to depend a lot on getting Carolina Water staff on the ground and further assess. We made a site visit with Carolina Water. Carolina Water's actually been back. So they have a pretty good idea. We're probably talking north of $1 million or $2 million, depending on the assessment of the collection system. The wastewater treatment plant, it has been overwhelmed by flow and is in a quite decrepit state. And then the spray irrigation system is far from fully functional. And so there's improvements to be made across the board on this wastewater system.
All right. The proposed order references report on the system prepared by Kimley Horn dated March 2024. Why was that prepared?
Mr. Higgins might be able to provide some context there.
Okay, Mr. Higgins.
Good morning, Dan Higgins for Redbird Land Company. Let me preface my answer by saying that, as is the case with Mr. Finley, we were engaged by other counsel to help them navigate the regulatory world. So I have a limited understanding of what transpired in the past. But if there's a specific aspect of this that you want me to address, I'd be glad to.
As a non-attorney, I'll just go on and say
Mr.
that
Junis, Mr. Higgins, what do you know about why there was a report prepared by Kimley Horn earlier this year?
I'm sorry. DEQ filed a civil action in Layton County Superior Court and against Redbird as the holder of the permit related to this facility, and counsel representing Redbird engaged Kimley Horn to have them prepare a report assessing the system.
All right. Mr. Junis, what do you know about why DEQ filed the complaint?
that was due to the the continuing compliance issues
Okay.
with
Okay.
flows far exceeding the permit, lack of samples being taken or samples exceeding the water quality standards, the system not being functional, for a number of reasons that are laid out within that complaint.
Okay. The proposed order indicates the system serves 180 customers, 180 customers. At full build out, let's assume that Carolina Water is going to get the moratorium lifted, which I think is a safe assumption. But how many customers are we looking at for this system?
So it can be over 400 lots.
Okay.
And it can grow even beyond that because there's undeveloped land in the area. I just want to be clear, getting that moratorium lifted is not a snap of the fingers for
I
Carolina
understand.
Water. This is a large chore. It's going to take time. For example, Outer Banks, Kinnicky, it took nearly a year, or about a year. And that is what they were facing here. You got to get the flows under control. If it's issues with the collection system, you might actually have to expand the plant to get the moratorium lifted to serve future customers. So right now, the focus is providing adequate service to the existing customer base.
Okay. Thank you for that clarification. As I read the proposed order here, EnviroLink's been the operator of this system since 2012. Is my understanding correct?
That's correct.
Okay. Has the public staff been in conversation with EnviroLink about its performance?
So when we went on the site visit, there were conversations with EnviroLink staff. There's actually an issue with even getting access to some of the lift stations. That conversation has not extended beyond that. Obviously this is going to be sort of corrected by attrition by having Carolina Water take over as emergency operator.
So Water does not intend to continue the contracted operations through EnviroLink.
That is not my understanding, and we would be maybe doing something different if that was the
Okay.
case.
Well, let me so the record is clear. Is it your understanding that EnviroLink will no longer operate the system once Carolina Water is appointed as emergency operator?
That's correct.
Okay. Let's see. The proposed order references stipulating parties, and I just want to preface my question with the understanding that you all have worked hard to get into this agreement and to reduce it to writing. And I can understand that, and I'm hesitant to do anything that jeopardizes the work you all have done here or that changes it. But there's a reference to stipulating parties, and stipulating parties isn't defined in the proposed order. So I need you all to define that for me on the record so that we can make that revision to the order.
So according to the settlement agreement and stipulation, that would be Lake Creek Corporation, DBA Bay Tree Utility Company, Redbird Land Company, LLC, and the public staff.
Okay. And last question, Mr. Junis, what have the customers been told about what has been proposed for this system in terms of Carolina Water's taking over and the associated increase in the rate?
So those conversations happened before this sort of plan was finalized. They are very aware that a rate increase was going to happen and recognize that to receive better service, that was probably going to be a necessity. So they know a large magnitude increase was coming, and then we also notified them before this staff conference last week, is my understanding.
Okay, thank you. All right, anything else that Mr. Finley or Mr. Higgins, you all want to add to Mr. Junis's responses to my questions?
I will say that this has been a long, protracted negotiation. The public staff has worked hard. There's a lot of tension out there, and we certainly would like to see it accomplished as quickly as possible.
I've got nothing to add to that other than to basically confirm that this has been there's been a lot of effort for the last 8 months to get get this to the finish line.
Well, I am curious about that. I mean, just from where we sit, from where I sit, the utility made an unauthorized sale of the water system, has done a poor job of operating the wastewater system. You got a party that's coming in willing to take this on. Where is help me understand where the tensions are for the utility here? And I just want to make sure I have a full understanding.
Well, go ahead.
I was just going to say Redbird is in receivership. And so one of the issues was coming up with the means to fund the contribution that is part of the stipulation that is before the commission. And so that was a challenging aspect of the situation.
One thing that's unusual about this is the CPCN is in the name of one entity and the permit from DEQ is in the name of another entity. How that happened, I do not know. And the Redbird is owned 51% by one owner and 49% by another owner. And those two owners don't get along at all.
Okay. All right. Okay. Let me see if there are questions. Anyone else? I'm going to take you in order of seniority. So just put your hands up if you have questions. Commissioner Hughes.
Do either of those owners live in this development? Do you know? Oh, do either of those two owners that don't get along, that are causing so much strife, do they live in this community?
That they do not, to my knowledge, but they have property there, the ownership of some of the property that is being developed. Mr. Jones, who's sort of, I'm trying to help here, lives in Charlotte. And the other guy, Carlisle, I don't think lives there.
Okay, thanks.
Yeah, just one quick question. It appears as if Lake Creek had basically posted $100,000 bond. Now that bond's going to be forfeited and that money is going to go to the emergency operator. How long does that process typically take?
So the public staff isn't intimately involved in that. Commission staff handles the forfeiture. However, in this case, this is a bond that is sitting in an account controlled actually by commission staff. So I hope that it'll be quite timely and can offset some of the capital investment, thereby reducing the costs that will eventually get to customers.
That was my concern, how quickly that would occur, because it would mitigate that impact.
They do a great job, so I think it'll be timely.
Thank you.
Commissioner Brawley.
Thank you, Chair Mitchell. We hear from another company called Redbird fairly frequently on water issues, but I'm hearing Redbird Land. And I'm assuming, but I want to clarify, you're not associated with the other water utility?
Yes, sir, I can confirm that. There's no association between Redbird Land and the other Redbird entity.
Thank you.
Thank you, Madam Chair. Just a question for Charles. Charles, as a new commissioner, over the past year, the chair and I have spent a considerable amount of time talking about these emergency situations. They seem to come up. DEQ between 2020 and 24 had sent out 40 different notices about noncompliance. What is the process? How does it get this bad before it gets to you or us? I mean, it's been, Council Higgins said 8-month process. Council Finley says it's been a long process. And, I'm just, in 2022, it was in bad shape. In 21, it was in bad shape. But how do we not get any more notice than this? The chair has to check with the Secretary of State to see if they're still in business. I mean, I don't understand how it gets this far down the road before we don't have, some sort of opportunity to resolve the situation. And then even in the notes, the commentaries in the record here or in our notes, it says real emergency. Why don't we get a heads up before it becomes a real emergency?
Yes, sir, Commissioner. Tucker, and you welcome to call me Chuck. I do not take offense to that. These situations are challenging. I'll tell you that I'm trying to take a more proactive approach through the Small Water and Sewer System Task Force. We are trying to at least signal to commission and commission staff that we are aware of these situations. But I also take the words of the chair quite seriously about bringing solutions. And I feel like here we have brought what is the start of a solution for this system. And I recognize it has taken a while, but I think that time was used wisely to get a significant contribution from one of the parties and to get consent and for this to move smoothly now, as opposed to protracted litigation that leads to additional costs that somebody who's going to want customers to pay for. So we are working on these. It is also trying to build an appropriate record of the existence of that emergency. I think that DEQ documentation, enforcement action, carries a lot of weight. And so we try to work with DEQ to build these cases. In the situation here where they've had to actually file a complaint and seeking injunctive relief, that filing provides almost all the documentation we need. Do I wish they didn't have to do all that work? Could we have taken action before then? There are situations where we have, and I hope going forward we can do that. So we're working on these. I'll tell you, this isn't the last one you're going to see here in the near future because of that work that we're doing. But this is good for customers. We are trying to really have an impact. And, you know, I think Commissioner Hughes in a hearing recently asked one of the witnesses about what are they proud of? Emergency operators and the real impact those have on these customers is one of the things I'm most proud of the work that I do for the public staff. So we don't take these lightly. And like I said, we want to bring you a solution.
Okay, just one more follow-up, and I appreciate Carolina Water Service or Aqua, whoever jumps in here that are financially stable enough to take these situations and take the bad and turn it into some good. Do you get notification about the non-compliance issues from DEQ, like back in 2020 and 2021? Would you have gotten those notices? I mean, I know there's silos in government bureaucracies, but it seems to me that if they're noticing 40 notices over a 4-year period, you would know about it, or do you know about it as soon as they start filing notices?
So we are not copied on those notices. Now, I have tried to really build up our relationship and the pipeline of information that flows between DEQ and the public staff and the commission. So that has improved as these situations pop up. They do make us aware now. Hey, we went and did an inspection. These are the results. Here's the report. This is bad. We think that there needs to be some sort of intervention. That communication has started to happen. And that's why you're seeing more and more of these come up. But we also have to build the solution. And sometimes it's not all that straightforward. For example, the complexities here with, you know, a different owner of the assets and property, a different holder of the permit, administratively defunct entity, like all these complications that we really do try to clean up for you all.
Well, Charles, it seems to me that you're saying that it's starting to happen now. Why can't DEQ and the public staff get a sincere understanding about just simply giving you a notification or copying you on these? It's just a standard practice for DEQ to copy you or whomever on the public staff before this gets to be that situation. Is that just something that's recently started happening in the last 8 months? Has it been going on a year, or is it just 30 days old? What have you got there?
The last couple of years, I mean, I took over my role in January of 2022, and this is something that is a priority for me. It's also a translation issue. They talk permit numbers and also system IDs, while we talk about companies typically. So we know Carolina Water, we know Aqua, we know Lake Creek, but the system names don't always match up, especially because some of these entities have hundreds of systems. So we're trying to work on the translation of, hey, this is a commission regulated entity. please funnel information to us. A lot of times DEQ wasn't aware that they were commission regulated entities. The other thing about notification, the annual reports require that the companies provide documentation of violations. Sometimes that information is not in the annual reports. So there's also a duty of the utilities to do a better job. And that's one mechanism for us to find out about some of the compliance issues.
Okay, I'll talk to you offline about maybe getting DEQ to communicate more with you. Thank you.
We will work on that. Thank you.
I mean, why don't you mention what DEQ's role in the Small Water and Sewer Task Force? I mean, DEQ has been at the table with you all for a couple of years now, so.
Correct. Yeah, no, I mean, we have been communicating both on the water and wastewater side. You also have a difference in how they regulate. On the wastewater side, the regional offices are more involved. So then you are interacting with multiple sets of staff, as opposed to on the public water supply section. It's more centralized in those interactions. So we've had more productive conversations and exchange of information on the water side. But I'll tell you right now, we're working on it. We kind of started at zero. And I think we've opened that valve probably about quarter halfway. And I'm ready to guzzle out of the hydrant here when we get it full blast.
All right, let me see if there are any additional questions. Go ahead, Commissioner Hughes.
I just want to be in the record, since we now have such a long record for this, is that these systems are not unique to the investor-owned systems that we regulate. There are these systems that are owned by local governments that are equally, if not equally, in trouble. One of the big differences is this state and this country has chosen to make federal tax dollars, and in many cases state tax dollars, available to assist these small, technically troubled, dangerous public health situations. And we have chosen not to make those funds available to investor-owned utilities in general. On the water side, it's a little bit easier. On the wastewater side, they're on their own. And I just think the record should be clear that we have the same challenges that local governments have, but there's been no acknowledgement that this is an issue that is a public good that requires public good support. So anyway, it's just largely, just going on the record, it's a very frustrating situation, particularly since the amount of money that has been pouring in to troubled water and wastewater systems over the last 4 years.
Yes, sir. And I would just echo, one thing as part of our due diligence was to make contact with local government utilities to see if they would be part of the solution. And I didn't get a lot of cooperation. And that's what we typically experience, that, you know, our private utilities are much more prone to step up and assist others than we've seen with some of the local government systems. Now, I'm still going to work on that. You know, I think there's a value to some of the regionalization that is actually near Bay Tree Lakes. But I echo your sentiment that, you know, those low cost dollars or even grant funds need to be distributed more to the private utilities. And I know there are company representatives here that want to provide an update on Helene that would echo that sentiment also.
And if I just may, Commissioner Hughes, since you bring this topic up, that notwithstanding the issues that these small water companies have just on a daily basis, but there's been a lack of funding also in emergency situations like Hurricane Helene, where small companies have not been able to access federal funding.
I'm aware of that, but thank you for getting that on the record too. It's just, it's an issue that goes beyond this commission, but thank you.
And this is just a quick question that came up in my mind when you're talking about, you know, this corporation being administratively dissolved. I mean, they can't enter into agreements to do what you're doing in this case, but they would not be able to sign a deed transferring an interest in land, such as an easement. Is that your understanding?
So I'm just gonna jump
Until
out
they're reinstated.
on the front end
Yeah.
that the assets are already transferred to Redbird Land Company. And I believe even the easements, but Mr. Higgins might be able to add to that.
Yes, Commissioner McKissick, it's, Redbird Land LLC owns the plant, owns the land where the plant's located, owns the utility assets.
Okay.
But to your question, and this was referenced by Mr. Junis, actually a dissolved corporation, my understanding is that a dissolved corporation, as part of its quote, winding up activities, may still execute deeds and do things to disperse assets. So there is a path for even a dissolved entity to be able to wind up its business, if you will, by dispersing and conveying assets.
Thank you.
If I could just add to that, just to provide a statutory site, 55-14-05 is regarding the effective dissolution states that a corporation may not carry on any business after dissolution except that business appropriate to wind up and liquidate its business affairs. And subsection 5 states doing every other act necessary to wind up and liquidate its business affairs, which is a pretty broad allowance there. And we think that the activities that Lake Creek will need to do to fulfill its obligations under the settlement agreement would fall under that.
Thank you.
All right, just a reminder, we've got a motion that's been seconded that the item be approved as recommended by the public staff. All in favor indicate with an eye. Is there anyone opposed? All right, that motion carries. Thank you all very much.
Thank you so much.
Okay, commission has before us our minutes from the December 9th staff conference. I'll take a motion, please. All right, it's been moved and seconded that the minutes be approved. All in favor? Is there anyone opposed? All right, those minutes are approved. All right, Ms. Boswell, did you want to introduce your new employee?
Good morning again. It is my pleasure to introduce the Public Staff Accounting Division's newest employee, Ms. Desiree Manfull. Ms. Manfull is a graduate of Simpson College in Iowa and has served both in public company and government roles, her last role being the last 3.5 years with the State of Iowa Department of Revenue. Thank you.
I'm happy to be here. Thank you.
Well, good morning, Ms. Manfull. We are happy that you're here. Welcome. All right, with that, any additional business before the commission before we adjourn? All right, hearing none, we'll be adjourned. Thank you very much.